Did you know in a medical malpractice trial in New York, even though I am calling the doctor as my first witness, I have the ability to cross-examine him? You want to know how crazy that is? Come join me as I share with you this great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. Today I'm coming to you from beautiful St. Martin. I'm here on vacation with my family and I have a few minutes to share this great information with you. Now, in New York, in a medical malpractice matter, I will typically call as my very first witness the doctor who treated you. And I do that in order to establish the basic standards of care and then to show to the jury and explain why we believe the doctor violated the basic standards of care. Typically, when I call a witness to testify, I am vouching for his or her credibility. I'm basically saying to the jury, okay, ladies and gentlemen of the jury, I'm calling this witness. He's here to give you some great information, tell you what happened, so let's listen to what he has to say. And then I get a chance to ask that witness questions in what's known as direct examination. And that's typically asking open-ended questions. Mr. Jones, tell us what happened. Mr. Jones, what did you do next? Mr. Jones, tell us more. And now the witness will go ahead and explain. But when I go ahead and call a doctor to the witness stand, I'm literally calling him as an expert witness in a malpractice case. If I call the doctor as the very first witness to establish what the doctor did and to establish that he may have violated the standard of care, the New York rules allow me, even though I'm calling him as my witness on my direct case, I have the ability to now cross-examine him because technically he's a hostile witness. His interests are adverse. They're against my own client, the patient, the injured victim. And because of that, I have the ability to question him, I have the ability to cross-examine him, and importantly, I have the ability to ask him hypothetical questions as well as ask him expert medical opinions about the treatment that he rendered to my client. Many years ago, if we called the defendant, the doctor who you are suing, as a witness on our particular case, the judges would often not allow us to cross-examine the witness. Why? Because they always said, listen, you are calling the witness on your own direct case. You are obviously vouching for his credibility. So therefore, you can't attack him in the form of cross-examination. Well, I'm pleased to say that that law has changed many, many years ago. And so now when we do call a defendant doctor to the witness stand, I have the ability to question him as if he is a hostile witness. I have the opportunity to cross-examine him and then establish what the basic standards of care are in your particular matter. So why do I share this great information with you? I share it with you just to give you an idea of what goes on in a medical malpractice trial, just to give you an insight into what happens. And you know, I realize you probably have questions of your own about your own particular malpractice matter. Well, if your matter happened in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I welcome your call. You can reach me at 516-487-8207 or by email at jerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Jerry Oginski. Have a wonderful day.